Hey everyone, welcome to this crucial explainer on the ethical boundaries and compliance rules for corporate directorships. Look, as you're building your career and your clients really start trusting your financial instincts, you are absolutely going to get asked to join a corporate board. It's an exciting milestone. But before you say yes, you really need to know exactly where the Institute of Chartered Accountants of India draws the line. So today we're unpacking the revised Code of Ethics to make absolutely sure you never accidentally put your practicing certificate at risk.
All right, let's take a quick look at today's agenda. We're going to cover the foundational ethical rule, define what a director simplicit is, run through a quick eligibility checklist, navigate the tricky stuff with relatives and auditors, map out permitted versus prohibited roles, and wrap up with the Section 8 dilemma.
Okay, jumping right in. Section 1, the foundational ethical rule.
So, to start off, we really have to ground ourselves in the core regulations of our profession. Everything stems from this one specific piece of legislation from the CA Act 1949. Clause 11 makes it pretty clear. Our default state is a strict restriction. Basically, as a practicing CA, you are not permitted to engage in any outside business or occupation. Your sole profession is chartered accountancy. Full stop. However, and this is a big however, the code does carve out some highly specific exceptions for company directorships. And honestly, it all comes down to the exact nature of that directorship role.
And that brings us to this clear dividing line. Think of board roles as falling into two distinct buckets. On the left side, we have general permissions. These are the roles you can literally accept today without having to ask the council, as long as you meet some very specific conditions. Then, on the right side, we have specific council approval. These are roles, usually the ones involving heavy daily management duties, that are strictly prohibited. You cannot take them on unless you actively petition the ICA and get a direct, special green light.
Moving on to Section 2, defining director simplicity. Now, this is the most common safe harbor for practicing CAs who want to join a board. The ICAI has essentially created this perfect little space for us to share our expertise without compromising our independence. They've clarified time and time again that a member in practice is allowed to be a director, but strictly as a director simplicit. What does that mean? Well, it means your role is entirely about oversight. You are at the board level, not the operational level. So you're attending quarterly strategy meetings, you're advising on broad financial governance, but you are completely removed from the day-to-day administrative duties of the company.
So looking at this comparison, it's really about separating acceptable advisory oversight from prohibited day-to-day corporate management. Under general permission, you can absolutely be a director simplicit for either a private or a public limited company. But you absolutely cannot be a managing director or a whole-time director. That means no signing routine vendor checks, no hiring daily staff, no running the operations. Without specific council approval, that's a no-go. But there is one super interesting exception here. If the company is specifically a management consultancy firm, you actually are allowed to run it as a managing director or a whole-time director. But for literally any other type of business, daily operations are completely off-limits.
All right, Section 3, Directorship Eligibility Checklist. Whenever you get offered a board position, you need to mentally run through this mandatory three-step checklist to make absolutely sure you're staying within the bounds of that general permission. Step 1, verify that you are only required to attend board meetings. Step 2, ensure your compensation is strictly sitting fees for those specific meetings. No salary, no standard remuneration, and no professional fees for routine work. And Step 3, confirm that absolutely zero time is going to be devoted to day-to-day routine administration, and that you aren't doing activities just to promote that company. If you can check off all three of those boxes, boom, you have general permission and you are fully compliant.
Let's get into Section 4, navigating relatives and auditors. Now, real-world practice is messy, right? You're going to face dilemmas with family interests and audit conflicts, especially with closely held family businesses. So never ever forget this absolute red line. The code is crystal clear here. If you or any of your partners in your firm are acting as the auditor for a company, the boardroom door is permanently closed to you. You simply cannot be a director of any kind for that specific company. The conflict of interest is an insurmountable barrier. Just don't even think about it.
But here is where it gets really interesting. Surprisingly, holding massive equity or having family involvement doesn't actually disqualify you from being a director simplicit. This is a massive nuance when you are advising entrepreneurial clients. The specific permission of the ICAI is not required even if your relative holds a substantial interest in the company. Plus, as a member in practice, you have general permission to be a promoter, director, and you can totally upload your signature as a subscriber to the memorandum and articles of association. And get this, there is absolutely no bar on the percentage of shares you can hold. You could literally hold 70, 80, or even 90% of the company's shares as a subscriber, and as long as you stick to those director's simplicit rules we just covered, you are perfectly compliant. Crazy, right?
Okay, Section 5, Permitted versus Prohibited Roles. Let's summarize all these complex rules into a definitive cheat sheet for your daily advisory practice. Take a mental snapshot of this table. You are generally permitted to act as an independent director, mostly because that role naturally focuses on board meetings and sitting fees, with no routine work. You're permitted to be a promoter director or a subscriber. You're permitted to be a director simplicit. And, as we mentioned earlier, you can even be the managing director of a management consultancy firm. Where you hit the wall, the absolute stop sign where you need specific council approval is if you want to become a managing director or whole-time director of a standard commercial company. That is the big no.
Finally, Section 6, the Section 8 dilemma. As you grow in your career, you're going to face some tricky edge cases. We've talked a lot about standard commercial companies, but what about the nonprofit sector? Consider Section 8 of the Companies Act 2013, which governs nonprofits. Does the Code of Ethics relax the rules for managing directors if the organization's motive is purely charitable? Well, the answer is a hard no. Even for a noble, charitable organization, the absolute prohibition on daily management remains intact. You cannot act as a managing director or whole-time director of a Section 8 company without seeking specific council approval. You are still completely restricted to a director simplicit role under general permission. So I'll leave you with this provocative thought. As accountants, our absolute greatest asset is our independence. When does helping a noble cause cross the line into compromising the very objectivity that makes our help valuable in the first place? Keep studying the code and always, always protect your professional independence. Thanks for joining me on this explainer, and I'll catch you next time.